Your Honour, may it please the Court, my name is Morris, Morris, initial C. I appear today on behalf of my client, Lynn Bako. I would firstly like to thank the Court for granting me the indulgence for allowing me to provide my submissions via video link. Your Honour, pursuant to the Criminal Code, this is a Section 590 AA application, and I confirm that I've emailed my written submissions to your associate this morning. My client has been charged with 5 counts of breaking and entering, committing an indictable offence pursuant to Section 241 of the Criminal Code, and 1 count of attempted arson. I am seeking for Your Honour today to find that the conduct of the police officers renders the admissions made by my client inadmissible. Your Honour, I will firstly consider the statutory breaches which alone are grounds sufficient to render the evidence inadmissible. Your Honour, may I again seek the indulgence of the Court and not give full case citations and refer to the Police Powers and Responsibilities Act as the PPRA. Thank you, Your Honour. My client is a 14-year-old Aboriginal girl from Townsville. For completeness, Schedule 4 of the Youth Justice Act defines the term child as a person who has not yet turned the age of 17. Section 420, subsection 2A of the PPRA states that unless the police are aware that my client has retained a lawyer, the police officer must inform my client that a representative from legal aid will be notified that they have been charged with the offence. Subsection 4 states that the police officer must not start questioning the person until they have either had the chance to talk to that support person, preferably in private, or at the very least, the support person be in the room when the questioning commences. On the facts, it is quite clear that this did not occur. Section 421 governs how a child must be questioned, and as my client is 14 years of age, this is highly relevant. Section 421, similar with Section 420, states that if a police officer wants to question a child, again, there must be the meeting with the support person, or at the very least, the support person must be in the room when the question commences. Your Honour, not only does my client satisfy Section 420, but she further engages Section 421 by being a child. The police commenced questioning at the school, and the questioning continued in the vehicle. It is also imperative that gratuitous concurrency is also considered. Section 21 of the Queensland Evidence Act demonstrates the importance of cultural background in these types of situations. It also considers whether the questioning style is then determined improper. It is clear from the transcript provided that my client was merely agreeing to the questions asked by the police and was feeling very intimidated and threatened by the whole circumstance. This is evidenced by her crying. Your Honour, I also submit that the prosecution are relying on my client's admissions on the recording, which should be therefore excluded. The recording should be excluded pursuant to Section 436, subsection 4. This section states that if the confession or admission is electronically recorded, then the confession must be part of the recording and the questioning of everything said within that questioning period. Your Honour, the transcript identifies several periods within that transcript where it actually states that it is inaudible. This is in clear violation of Section 436. On the current facts, there is also no evidence to suggest that my client has waived her rights to having a support person. Therefore, Section 420 and Section 421 are clearly applicable and have been breached. Your Honour, these statutory breaches alone are evidence for it to be inadmissible, but this is further established when considering the exclusionary discretion available pursuant to public policy. Chief Justice Barwick, in the matter of Ireland, stated that convictions obtained by the aid of unlawful evidence may be obtained at too high a price. This was further reinforced in Bunnings and Cross, where it was established that 5 elements need to be considered. The first element is whether the conduct resulted from genuine mistake or a deliberate breach of law. Your Honour, on the facts of this case, one would presume that the police officers could clearly see that my client was a child and that she was Aboriginal. It is therefore undoubtedly clear that my client would require a support person prior to any type of questioning. Element 2 considers that if it is not a mistake, it cannot be considered unless it is vital to the Crown case and of a perishable nature. Your Honour, there is no reason as to why the police could not lawfully obtain this testimony from my client. There was no risk of the police losing such evidence from my client and was therefore not perishable. The third element is, was the conduct a genuine response to pressing circumstances? Again, Your Honour, this is clearly a case where the police could have adhered to the law and waited for the support person to conduct the questioning. There was no urgency in this scenario that permitted the police to openly breach my client's rights. Element 4 considers the gravity of the charges laid. My client has not been charged with murder or another grave offence, but charged with breaking and entering and a count of attempted arson. The final element is if the conduct in getting the evidence breached a statute. Your Honour, I refer to my earlier submissions where I identified at length the statutory breaches that the police officers made in respect of the PPRA. Your Honour, I believe that by addressing these 5 elements in Bunning and Cross, it is abundantly clear that the evidence should be excluded in relation on the grounds of public policy. If my client's alleged confession was to be maintained, this would transcend to a great miscarriage of justice against my client and empowering the police to have a blatant disregard for the law. Your Honour, that concludes my submissions. Thank you.